FDCPA and look at the definition section, because this is really, really important. And I feel like it's super, super important to learn these definitions, because one, you know, a definition that you can Google is not going to be the same as the lawful definition. And once you learn the definition, you're able to understand the context and study a little bit better. Also, we can look here, 15 USC 1692. Under Title 15 is where the Fair Debt Collection Practices Act starts. But under the CFR, it's CFR 12 CFR 1006.2 is where the definitions begin. Okay, so if you want to go, and I'm on the Consumer Financial Protection Bureau website. So if you want more in depth and you really want to really want to get your study on, come to the CFPB in order to, you know, have them break it down to you a little bit more. So let's go to Act. FDCPA means the Fair Debt Collection Practices Act. Okay, attempt to communicate means any act to initiate a communication or other contact about a debt with any person through any medium, including by soliciting a response from such person. An attempt to communicate includes leaving a limited content message as defined in paragraph J of this section. And then, as you can see here, it gives definitions, right? So examples. Defines an attempt to communicate as any act to initiate a communication or other contact about a debt with any person through any medium, including by soliciting a response from such person. An act to initiate a communication or other contact about a debt is an attempt to communicate, regardless of whether the attempt, if successful, would be communication that conveys information regarding a debt directly or indirectly to any person. For example, assume that a debt collector places a telephone call to a person about a debt. Regardless of whether the debt collector reaches the person, the debt collector has attempted to communicate with the person. Assume that the debt collector places a telephone call to a person about a debt and leaves a voicemail message. Regardless of whether the voicemail message consists solely of a limited content message or includes content that conveys directly or indirectly information about a debt, the debt collector has attempted to communicate with the person. So that is an attempt to collect the debt. Attempt to communicate with you. Let's go down to Bureau. Means the Bureau of Consumer Financial Protection. I know we've heard Equifax, TransUnion, and Experian as being credit bureaus. They are not credit bureaus. They are consumer reporting agencies. Why do they call themselves credit bureaus? To make themselves seem bigger than what they actually are. Okay? Experian, TransUnion, and Equifax have a regular LLC just like anyone else. They are not backed by the government. They are not backed by the government. The government regulates. The CFPB, the FTC is who regulates these credit reporting agencies. I also believe they do this because when you're studying, subconsciously, if you keep saying credit bureau, credit bureau, credit bureau, and then you go to study the law, you don't make that connection of a credit reporting agency. You make that connection of a credit bureau. Communicate or communication means the conveying of information regarding a debt directly or indirectly to any person through any medium. Is your consumer report not a medium? Is that not a way to get in contact with you? Do you check your credit report? Do you have a credit report? If you check your credit report, is that not a way of communicating with you? This is supposed to be a pile of information that conveys you as a person and your reputation. But let's see. Any medium provides in relevant part that a communication can occur through any medium. Any medium includes any oral, written, electronic, or other medium. For example, a communication may occur in person or by telephone, auto recording, paper document, mail, email, text message, social media, or other electronic media. Information regarding a debt provides in relevant part that a communication means conveying information regarding a debt. A debt collector does not convey information regarding a debt directly or indirectly to any person if the debt collector leaves only a limited content message, because again, that is an attempt to communicate, but we're at communicate or communication. Okay. Consumer means any natural person, whether living or deceased, obligated or allegedly obligated to pay any debt. This is super important, and you have to really pay attention to the words that Congress uses, because it says means any natural person. That's important too, because when you get into studying, you'll understand that a person means either a natural person or a corporation. So it's giving you the opportunity to choose, right? Which is where your straw man comes in at, right? That fictional person, your all caps name, that is where that's where that comes into play, right? Whether living or deceased, obligated or allegedly obligated to pay any debt. So Congress is giving you another option. It's allegedly obligated or you're obligated to pay any debt. Consumer financial protection product or service. Creditor. All right. Creditor means any person who offers or extends credit, creating a debt, or to whom a debt is owed. Or to whom a debt is owed. The term creditor does not, however, include any person to the extent that such person receives an assignment or transfer of debt in default solely to facilitate collection of the debt for another. So that's pretty much telling you that debt collectors are not creditors. And the importance of them putting the definition of a creditor under the FDCPA was to make it clear, because we know that a lot of the times debt collectors will try to act like the original creditor is still trying to collect, or that they are the original creditor, right? So when that happens, not only do you need to request from the original creditor, hey, are you still trying to collect on this debt? What is the status of this debt? Have you sold this debt? If you have sold this debt, for how much? These are the things that I need to know. Who did you sell it to? You need to know this information. You want to know why? Because even though it says ABC collections on your credit report, that could have been sold to five different debt collectors before it even reached them, right? So these are things that you got to pay attention to, and these are the questions that we have to ask. Remember that we're in the positions that we are, especially today, with companies violating us because we don't know. Not only do we don't know, we don't ask the right questions. So when you are asking them, hey, who did you sell it to? All of them. I want all of them. Not specifically, did you sell it to ABC Collection? Don't make their job harder than what. No. Make them do the work. Okay? All right, debt. Debt means any obligation or alleged obligation of a consumer to pay. Y'all, I'm lost for a second. Hold on. All right, debt. Debt means any obligation or alleged obligation of a consumer to pay money arising out of a transaction in which the money, property, insurance, or services that are subject of the transaction are primarily for personal, family, or household purposes, whether or not the obligation has been reduced to judgment. Okay, that's what debt is. Defines that to mean, in part, any obligation or alleged obligation of a consumer to pay money arising out of a transaction. In turn, defines consumer to mean any natural person obligated or allegedly obligated to pay any debt. Only natural persons, therefore, can incur debts as defined in 1006.h. Okay, so let's look at incur definition, right? Become subject to something unwelcome or unpleasant as a result of one's own behavior or actions. So you have to, even little things like that the word choice that Congress uses, they put this unwelcoming and this bad thing on debt. which we'll get into another time. But debt collector means any person who uses any instrumentality of interstate commerce or mail in any business, the principal purpose of which is the collection of debts, or who regularly collects or attempts to collect directly or indirectly debts owed or due or asserted to be owed or due to another. So when you look at debt collectors, we often fail to realize that repo companies are debt collectors, that attorneys are debt collectors. Like, these people are debt collectors. They are trying to collect on behalf of someone else, either directly or indirectly. So when it comes to a debt collector, it's not just your third party debt collector. You will be surprised how much, who falls under the category of, or who is governed based off of their practices under the FDCPA. Notwithstanding paragraph I2VI of this section, the term debt collector includes any creditor that, in the process of collecting its own debts, uses any name other than its own that would indicate that a third person is collecting or attempting to collect such debts. So, does the creditor fall under the FDCPA? Again, normally creditors fall under the Truth in Lending Act, because that is the law that governs consumer credit transactions. But Congress also tells us in the FDCPA, under certain circumstances, right, that creditors can be subject to the FDCPA. For purposes of 1006.22e, the term also includes any person who uses any instrumentality of interstate commerce or mail in any business, the principal purpose of which is the enforcement of security interests. I want you to think about your contracts, right? I want you to think about your contracts and who really is debt collectors and who really are creditors. Because when you look at your contracts, a lot of times your contract says this debt is assigned to. Remember, when we looked at the definition of creditor, it says the term creditor does not, however, include any person to the extent that such person receives an assignment or transfer of a debt. How many contracts have you signed that the finance company says that it was transferred over to the finance company? These are the things that we have to think about, right? It's not about what we think. It's literally about what the law says. Okay? This tell you what a debt collector excludes. Okay, any officer or employee of a creditor, while the officer or employee is collecting debts for the creditor in the creditor's name. Okay? Any person while acting as a debt collector for another person, if the person acting as a debt collector does so only for persons with whom the person acting as a debt collector is related by common ownership or affiliated by corporate control, and the principal business of the person acting as a debt collector is not the collection of debts. Okay, so when people might bring this up when they talk about, oh yeah, well, attorneys are not governed under the FDCPA. Nope. It says the person acting as a debt collector does not only for persons and because it can, and this is why you have to really read to understand the law for yourself, because you would assume that the person acting as a debt collector, well, how else can you act as a debt collector if you're not here to collect debts? So when Congress writes it, it's kind of in a way to, it seems like they kind of write it in a way that debt collectors really can't win, right? They really can't win. But it excludes any person while acting as a debt collector for another person if the person acting as a debt collector does so only for a persons with whom the person acting as a debt collector is related by common ownership or affiliated by corporate control. How many times, right? Because 9 times out of 10, when it comes to a creditor, unless they just all own law firms or they're affiliated by corporate control, where they control that whole law firm, they're outsourcing for these attorneys. right? They're paying these attorneys. They're outsourcing. These are companies that are not affiliated or associated with them, other than I am hiring you to do a service. Other than that, I don't I don't dictate what goes on at ABC Law Firm, right? And the principle, and not or. Pay attention to that as well. It's not or, but it's and. This means that both has to happen. The principal business of the person acting as a debt collector is not the collection of debts. That's the one that really blows the whole of people using this as um, attorneys aren't governed under the FDCPA out of the water, because again, you hire an attorney because you want some type of compensation. So you are a debt collector, right? Any officer or employee of the United States or any state, to the extent that collecting or attempting to collect any debt is in the performance of the officer's or employee's official duties. Any person while serving or attempting to serve legal process on any other person in connection with the judicial enforcement of any debt. Any nonprofit organization that, at the request of consumers, performs bona fide consumer credit counseling and assists consumers in liquidating their debts by receiving payment from such consumers and distributing such amounts to creditors. Any person collecting or attempting to collect any debt owed or due, or asserted to be owed or due to another, to the extent such debt collection activity is incidental to a bona fide fiduciary obligation, concerns a debt that such person originated, concerns a debt that was not in default at the time such person obtained it, or concerns a debt that such person obtained as a secured party in a commercial credit transaction involving the creditor and a private entity, to the extent such private entity is operating a bad check enforcement program that complies with Section 818 of the Act. We're going to skip down to person, just so you can see, includes natural persons, corporations, companies, associations, firms, partnerships, societies, and joint stock companies. State means any state, territory, or possession of the United States, the District of Columbia, the Commonwealth of Puerto Rico, or any political subdivision of any of the foregoing. So that is it for the definitions, y'all. The most important that you need to read and understand: consumer, creditor, debt, debt collector. Those are the most important, and person. Those are the most important definitions that you really need to understand and overstand when it comes to the definition section of the FDCPA. So with that being said, you guys, I will be doing another video explaining another section of the FDCPA. If you want the full class and the breakdown of each section, because you have all of these, you have acquisition of location, harassment, false and deceptive, unfair or unconscionable means, collection of time barred debts. You have all these parts of the FDCPA. I go over each and every single part of the FDCPA and how you can use it against debt collectors, attorneys, law firms, all of these companies in the FDCPA Masterclass. So it is in the link in my bio if you would like to check out the full class. If you are being sued by a debt collector, that I will leave that in the description box as well. If you are having a problem with going back and forth with a debt collector, I will leave again the FDCPA Masterclass and the debt collector lawsuit masterclass in the description box below, to make it easier for you guys that are having trouble. But with that being said, I will see you guys in the next video.